importance of the vocational expert is that the judge is unable, in theory, to make that vocational decision to determine whether there are jobs or whether that person hypothetically could perform their past relevant work or some other work. And that's the idea of a vocational expert, that the judge, in the process, as the judge would pose a hypothetical, assuming someone of the claimant's age, education, work background, etc., and with the following limitations. Is that claimant, is that person able to do their past relevant work? Yes or no? And I tell the client the answer will almost always be yes. Judge will say, if I had additional limitations, can that person do past relevant work? No. Are there any other jobs which exist in the economy? Apparently there are a lot of jobs either working as security monitors, telephone sales, or we apparently have a lot of jobs in St. Louis and Missouri and Illinois which involve parking lot attendants. I guess if you have an unemployed client, there must be thousands of those available because they always come up in the hearing. But that's where the vocational expert comes into play. So it can be key. The vocational expert will use in the Dictionary of Occupational Titles, which is kind of a defunct mechanism, but they still refer to that. In theory, it will provide them information regarding the amount of jobs and job descriptions. And then a vocational expert will testify and tell you whether their testimony is inconsistent with the DOT, or Dictionary of Occupational Titles. You'll notice in the materials I've included that Social Security ruling talking about the use of the vocational expert. And again, that's, if you'll bear that in mind, mostly determined, for starters, did your ALJ fail to use a vocational expert when they should have? That person, if they are unable to do their past relevant work, there's a shift in the burden to the Social Security Administration to show there are other jobs they can perform. Now, in the federal courts in which I practice, they don't view that as a complete shift in the burden of proof. They still hold us to that, but they do view it in the Eighth Circuit as a shift on that part of the burden, that the Social Security Administration has a burden to show that there are jobs which are available. So that if you've got somebody who is aged and unable to do past relevant work, often a construction laborer, and they don't use a vocational expert, then you may have an issue there, because they're going to have a hard time showing that there are any other jobs which exist in the economy, and that's their burden to document that, at least in our circuit. You should be familiar with your own circuit rules and play and mark that in. I keep a list of vocational questions when I set up my file. Now, my secretary sometimes goes, can't we get rid of these because you don't use them a lot? Well, that's true. I may not use them in a majority or many of the cases, but I do want to have those available in there to have available for them. You'll notice that the Social Security is looking at the Occupational Information Systems Project, trying to determine, and that information provided in your packet, understanding the issues of determining occupations. When you look at the DOT, Dictionary of Occupational Titles, you see a lot of acronyms. Why is that not surprising in this area? And what does that mean? Well, example, if they're describing a job and they'll tell you it's got a GOE, strength, GED, RM, L, SVP, and DLU, you almost want to add MIC at the end of that. What does all that mean to you? Well, they're looking at a couple things. The GOE is the Guide for Occupational Exploration, and they're looking at determining whether there are, that's a comparison. Are there similar jobs? The strength has to do with the nature of the job requirements, both of the, and most often, the past relevant work. They'll look at GED in this case is the educational requirements. SVP has to do with a specific vocational preparation. Is it going to be semi-skilled, skilled, unskilled? How much time is it going to take a person to adapt to that? And the date last updated. They may have reasoning requirements for that job, and they may also have issues regarding the ability to develop your skills. So when they're talking about something under the DOT, ordinarily the vocational expert will actually give you the DOT site at the hearing. Always write those down. Your goal is to win at that hearing, but it's also to make a note that what can you do on appeal? Has the ALJ done that correctly? And I want to look at my DOT sites. Have they correctly interpreted that? Now, there are some vocational issues or implications for pain and mental health issues. My approach generally is going to be, well, almost always going to be rather, that I focus on those chunks of downtime. Social Security wants to take those things the client can do sometimes and extrapolate them into what they can do all the time. So heaven forbid they ever did any housework, because heck, that means they can be a housekeeper, because if they can clean their house an hour a day, or if it takes them 3 days to clean a house they could do in a morning, taking care of their own house, well, that must mean they can be a housekeeper 40 hours a week. So in terms of pain and mental health issues, I'm really looking for those chunks of downtime. From a vocational point, they will acknowledge that if you are unable to stay on task, I've heard judges use 15%. I think you're better off using 25% of the time. If they can't maintain persistence, concentration, and pace and stay on task for 25% of the time or longer, there are no jobs that person can do, and your vocational expert will admit that. So if you can tie that into a hypothetical, if the judge won't ask it, then you have a chance. After the judge has asked the hypothetical, after hearing your client's testimony and any other testimony, then you can, if they haven't asked that, you can ask them if there's a basis to show that your client is unable to stay on task, especially with pain and mental health issues. If their pain is so bad that they have days when they can't report, most vocational experts will tell you that over 2 absences per month makes you unemployable. Certainly they'll tell you 3 even in a highly skilled position, 2 in almost every other position. So during my client's testimony, I want to make sure I've included hitting those chunks of downtime. Let's say your client has a headache, severe migraines, a variety of other issues. Well, I will want to have the client talk about, not about days when they have a headache, days when they have a headache so bad that they're throwing up, that they've got to lay in a darkened room, when they went to a store and they had to leave the store, have somebody drive them home and lay down for 2 hours. Because if you can put that in the record, there's a basis for you to argue to the vocational expert that those are periods of time they cannot stay on task or would require an absence from work. And no matter what else they say that person can do, if you can establish the inability to stay on task or concentrate, again, some say 15, I'd say use 25, they'll all agree to that, 25% of the time, or 3 or more days absent a month, they will the vocational expert will agree that person's unemployable. Now, where does the issue come in? The administrative law judge may tell you, I don't find them credible on that issue. And to be honest, the credibility decision is almost never, or very seldom going to be successful on appeal. Mm-hmm. So if you're hanging your hat on that, But what we do tell the client, and I talk to him about, is if he believes you, he's got to find you disabled, he or she. And it gives you a basis to argue, because if the judge doesn't adequately frame the hypothetical and it's not consistent with the record, then you have a chance to argue that. So again, on pain, I'll be focusing on missing those days of work and those periods of time in which they're unable to concentrate. Mental health disorders, the same type of emphasis. I want to look on those times when they can't stay on task. If they are bipolar, I want to know how often it's so extreme that they can't do other tasks. Again, pointing that out, because as I tell the clients, most people can do some jobs, sometimes, some days. It's the inability to be there all day long, all week long, that makes them unable to work.